Next, I address Mr. Naletilić and then Mr. Martinović grounds of appeal under which they allege that the trial chamber committed various errors in making its factual findings. I will not summarize each of these grounds of appeal in detail. Rather, I will focus on the merits of Mr. Naletilic's first, third, sixth, and 21st ground of appeal, as well as parts of his fourth and eighth grounds. Mr. Martinovic's subgrounds will be addressed insofar as they relate to the use of detainees to assist in the looting of private property. With respect to the remaining grounds of appeal on the trial chamber's factual findings, the appeal chamber has dismissed them for reasons explained in the judgment. Turning first to Mr. Naletilic's grounds of appeal, the trial chamber found that throughout the time relevant to the indictment, he was the overall commander of the KB and the attached ATG units. Mr. Naletilić challenges the trial chamber's finding of a superior subordinate relationship supporting criminal responsibility under Article 7(3) for certain offenses. He contests, in particular, the trial chamber's reliance on Exhibit PP 704, a salary list for members of the KB and ATG units dated November 93, on the testimony of witness Falk Simang, and finally on Exhibit PP 928, the so-called Radoš diary for a finding of Article 7(3) criminal responsibility. Having considered each of the instances in which Mr. Naletilić claims that the trial chamber erred in relying on the salary list for members of the KB and ATG units, the appeal chamber finds that, with the exception of two of them, the trial chamber's reliance on this exhibit did not constitute an error. The first such instance concerned the trial chamber's finding, based only on the salary list, that Miro Marjanović was a subordinate of Mr. Naletilić at the time when he administered beatings to prisoners in the Heliodrome. The trial chamber did not conclude that Miro Marjanović was under the command of Mr. Naletilić prior to or after November 93, nor did it make a finding as to when Mr. Marjanović administered beatings on the prisoners in the Heliodrome. The appeal chamber has reviewed the evidence of those witnesses whom the trial chamber relied on for its finding that Miro Marjanović was among the most notorious perpetrators of beatings at the Heliodrome. With the exception of one witness who refers to an incident in which he was beaten by a certain Marjanović in late May 93, none of the other witnesses provide specific dates as to when Miro Marjanović beat prisoners at the Heliodrome. The appeal chamber therefore finds that no reasonable trier of fact could have found, solely on the basis of the salary list, that it had been established beyond reasonable doubt that Miro Marjanović was a subordinate of Mr. Naletilić when he administered beatings to prisoners in the Heliodrome. This error leads to a miscarriage of justice, since, absent the finding that Miro Marjanović was a subordinate of Mr. Naletilić at the relevant time, Mr. Naletilić could not have been found responsible pursuant to Article 7(3) for the cruel treatment and willfully causing great suffering inflicted by Miro Marjanović on prisoners at the Heliodrome. The second instance concerned the trial chamber's finding that Ivica Kraljević, the warden of the Ljubuški prison, was the same Ivica Kraljević listed in Exhibit 704. Additional evidence admitted on appeal shows that the warden of Ljubuški prison, Ivica Kraljević, was not the same Ivica Kraljević that appears listed as a member of the KB in Exhibit 704. However, for reasons which I will state later on, it is not necessary for the appeal chamber to address the consequences of the trial judgment of this finding. With respect to the testimony of witness Falk Simang, the appeal chamber dismisses all of Mr. Naletilic's arguments concerning the trial chamber's alleged errors in relying upon this evidence for its factual findings. Turning now to the issue of the Radoš diary, Mr. Naletilić argues that the trial chamber erred in admitting the Radoš diary as evidence in rebuttal because it did not amount to evidence in rebuttal. Rather, he argues, the diary was used to support and bolster the prosecution's case in chief. The appeal chamber notes that it will intervene to exclude evidence in the event that it finds that the trial chamber committed a discernible error in the exercise of its discretion to admit evidence, and that this error resulted in unfair prejudice to the appellant, thereby rendering his trial unfair. In the present case, while the trial chamber directed itself to the correct legal standard on the admissibility of rebuttal evidence, it erred in applying this standard to the facts. It found that the Radoš diary was admissible as rebuttal evidence on the basis that it concerned, and I quote, the events related to Sovici and Oliani. The appeal chamber notes that the events in Sovici and Oliani formed an integral part of a number of charges in the indictment, and thus were fundamental to the case brought by the prosecution. Therefore, evidence pertaining to the events in Sovici and Oliani should have been brought as part of the prosecution case in chief, and not in its case in rebuttal. However, the appeal chamber notes that Mr. Naletilić had ample time and opportunity to challenge the Radoš diary and to respond to the allegations therein concerning the events in Sovici and Oliani, and did make extensive use of this opportunity at trial. The appeal chamber therefore finds that Mr. Naletilić did not suffer unfair prejudice as a result of this error. For these reasons, the appeal chamber allows in part Mr. Naletilic's first and third grounds of appeal. His fourth, sixth, and eighth grounds of appeal are dismissed in their entirety. Next, under his 21st ground of appeal, Mr. Naletilić argues that the trial chamber erred in finding that he had the requisite mens rea regarding the activities carried out by ATGs in the Obuški prison and in Mostar. Mr. Naletilic's arguments concerning his responsibility for the activities of ATGs in Mostar are dismissed for reasons set out in the judgment. With regard to Ljubuški, the trial chamber's finding that Mr. Naletilić had reason to know about the mistreatment of prisoners by his subordinates in Ljubuški prison is essentially based on the fact that he was present when KB soldiers severely mistreated witness Y on one occasion, while the bus transporting witness Y and other prisoners to Ljubuški prison got stuck in the mud. The appeals chamber notes that the trial chamber failed to make a finding that Mr. Naletilić was on notice that his subordinates would return to Ljubuški prison to mistreat prisoners there. As noted by the trial chamber itself, the evidence shows that on the particular occasion when he witnessed the mistreatment of witness Y on the way to Ljubuški, Mr. Naletilić told his soldiers to stop the beating and to get going. Although the trial chamber found that evidence from several witnesses regarding the complaint of the warden of Ljubuški prison about his inability to prevent KB soldiers from entering the prison and mistreating prisoners was telling, it did not find that Mr. Naletilić knew of that complaint. The appeal chamber therefore finds that no reasonable trier of fact could have found beyond reasonable doubt on the sole basis of this incident that Mr. Naletilić had reason to know that his subordinates would commit such crimes in Ljubuški prison. The trial chamber's error led to a miscarriage of justice, since without proof of Mr. Naletilić's mens rea with respect to Ljubuški prison, Mr. Naletilić could not have been held responsible pursuant to Article 7.3 for the cruel treatment and willfully causing great suffering inflicted upon prisoners at Ljubuški prison and for persecutions by these underlying acts. For these reasons, the appeal chamber allows in part Mr. Naletilić's 21st ground of appeal. As part of his second ground of appeal, Mr. Martinović submits that the trial chamber erred in finding him responsible for unlawful labor under Article 7.3 of the statute for the use of the detainees' witnesses F, YY, and AB to assist in the looting of private property. Witness F gave evidence that Stela's soldiers were present while he was forced to assist in looting, but that he only recognized one of them was the commander, namely Zubak. On cross-examination, the witness gave evidence that he did not know with certainty which unit Zubak belonged to. In light of this, the appeal chamber finds that it was not open to a reasonable trier of fact to conclude on the basis of witness F's testimony that Zubak was Mr. Martinovic's subordinate. The trial chamber therefore erred in finding that Mrs. F was forced to loot by Mr. Martinovic's soldier. With respect to witness AB, the appeal chamber finds that in light of the witness's testimony that he did not know whether it was Mr. Martinovic's soldier that forced him to loot, it was not open to a reasonable trier of fact to conclude that witness AB was forced by Mr. Martinovic's subordinates to assist in looting. The appeal chamber notes, however, that these errors did not lead to a miscarriage of justice, because the trial chamber was still presented with and relied on the evidence that Mrs. YY was forced to loot by Mr. Martinovic's subordinates, which Mr. Martinović has failed to demonstrate was in error. Mr. Martinovic's sub-ground of appeal is therefore dismissed. I will now address Mr. Martinovic's sub-ground of appeal and the prosecution's fourth ground of appeal on cumulative convictions. Mr. Martinović challenges cumulative convictions as such and argues that his cumulative convictions based on the same conduct cause him prejudice because the same act is given multiple and aggravating characterizations. The appeal chamber recalls that the permissibility of cumulative convictions as well as the principles governing their application is well established in the practice of the International Tribunal, and that its jurisprudence recognizes that multiple convictions serve to describe the full culpability of a particular accused or provide a complete picture of his criminal conduct. The appeal chamber finds no cogent reasons for departing from this jurisprudence. As a result, Mr. Martinovic's sub-ground of appeal is dismissed. The prosecution submits that because an underlying act of the crime of persecutions did not amount to a crime under Article 5 of the statute, persecutions is necessarily legally distinct from other Article 5 crimes. Specifically, the prosecution argues that torture and persecutions as Article 5 crimes each contain elements that are materially distinct from those of the other. The trial chamber found Mr. Naletilić responsible for persecutions under Article 5H of the statute, torture under Article 5F of the statute, and torture under Article 2B of the statute for his treatment of witnesses FF and Z. However, the trial chamber held that when there are positive findings in relation to both persecutions and another crimes against humanity, the conviction that he has upheld is that of persecutions. For that reason, upon a comparison of multiple convictions based on the same acts, the trial chamber entered convictions only for persecutions under Article 5H and for torture under Article 2B of the statute in relation to the mistreatment of witnesses F, F, and Z. It therefore entered no conviction for torture under Article 5F for this incident. The appeal chamber recalls that in the Kordic and Cherkes appeal judgment, it held that intra-Article 5 convictions under the statute for persecutions as a crimes against humanity with other crimes against humanity may be permissibly cumulative under the Celibici test. The appeal chamber, Judge Schomburg and Judge Gunay dissenting, finds that the definition of persecutions contains materially distinct elements not present in the definition of torture under Article 5 of the statute, namely the requirements of proof that an act or omission discriminates in fact and proof that the act or omission was committed with specific intent to discriminate. Torture, by contrast, requires proof that the accused caused the severe pain or suffering of an individual, regardless of whether the act or omission causing the harm discriminates in fact or was specifically intended as discriminatory. Thus, cumulative convictions on the basis of the same acts are permissible in relation to these crimes under Article 5 of the statute. The appeal chamber finds that the trial chamber's conclusion was erroneous in disallowing the conviction against Mr. Naletilić for torture as a crime against humanity pursuant to Article 5F of the statute in relation to the mistreatment of witnesses F, F, and Z, and allows the prosecution's fourth ground of appeal. Let me now come to sentencing. With regard to sentencing, Mr. Martinović has appealed the determination of the trial chamber under his third ground of appeal. Mr. Naletilić challenges his sentence under his 25th and 40th ground of appeal. A number of their submissions have been considered by the appeal chamber and dismissed for lack of merits. However, the appeal chamber has found that the trial chamber erred in three respects, which I will summarize in turn. In the first place, Mr. Martinović submits that the trial chamber erred in failing to consider in mitigation of sentence that he facilitated his transfer to the International Tribunal through the following steps. First, upon learning of the indictment against him, he personally requested his own extradition to The Hague. Second, after the decision by the Zagreb County Court on his transfer was rendered, he filed a submission expressly waiving his right to appeal the decision, and requesting his prompt extradition. The appeal chamber observes that on the balance of probabilities, it has been proven that Mr. Martinović waived his right to appeal the decision of the Zagreb County Court. It has not, however, been shown on the balance of probabilities that Mr. Martinović personally requested his own extradition. The appeal chamber considers that mere facilitation of the transfer process cannot be considered voluntary surrender, but that such facilitation may itself be considered as a mitigating factor. In light of the specific circumstances of this case, the appeal chamber considered Mr. Martinović to have facilitated his transfer to the International Tribunal. The trial chamber therefore erred in stating that the circumstances of transfer to the tribunal cannot be considered in mitigation of sentence. However, given that Mr. Martinović was involved in criminal proceedings at the time of his transfer, and that there is some indication that the time saved by facilitating transfer would have been approximately 1 month, the appeal chamber does not consider that this mitigating circumstance would have been given significant weight as sentencing. The trial chamber thus did not commit an error affecting the judgment. Secondly, Mr. Martinović submits that despite noting his claims that he helped his BH Muslim neighbors, that his general attitude is the same towards BH Muslims and BH Croats, and that BH Muslim detainees were helped by him and wanted to stay with him rather than in other units, the trial chamber failed to address them in mitigation when determining his sentence. The appeal chamber finds that the trial chamber's failure to address these claims of assistance to BH Muslims in the sentencing part of its judgment was in error under the reasoned opinion requirement. However, whether or not Mr. Martinovic's assistance was actually taken into account by the trial chamber as sentencing as a mitigating factor, it is entitled to little weight and would have no impact on Martinovic's resulting sentence. In the third place, both Mr. Martinović and Mr. Naletilić submit that the trial chamber erred in holding that their command roles amounted to an aggravating factor in sentencing. The appeals chamber has on several occasions confirmed that a trial chamber has the discretion to find that direct responsibility under Article 7.1 of the statute is aggravated by a perpetrator's position of authority. The wording of the sentencing section of the trial judgment suggests that the trial chamber's consideration of Mr. Martinovic's and Mr. Naletilic's command roles did not only pertain to its evaluation of the form and degree of their participation in the crimes, but went further. The trial chamber found that Mr. Naletilić and Mr. Martinovic's positions as commanders rendered their roles more serious. Insofar as this relates to their conviction under Article 7.1 of the statute, the appeal chamber finds no error. However, inasmuch as this relates to their convictions under Article 7c of the statute, the appeal chamber considers there to be an error. Given that the trial chamber is unclear as to exactly which counts this factor was considered to aggravate, the appeal chamber finds in Mr. Naletilić and Mr. Martinovic's favor that the trial chamber erred. However, the appeal chamber considered that in light of the gravity of the crimes for which Mr. Naletilić and Mr. Martinović were convicted and the circumstances of the case, this error has no impact on the sentence. In conclusion, the appeal chamber notes that it has set aside, in part, a few of the convictions entered by the trial chamber against Mr. Naletilić and Mr. Martinović. However, taking into account the particular circumstances of this case, as well as the form and degree of the participation of Mr. Naletilić and Mr. Martinović in the crimes affirmed on appeal, as well as the seriousness of those crimes, the appeal chamber finds that the sentences imposed by the trial chamber against them are within the range that a reasonable trial chamber could have ordered. I will now read out in full the operative paragraphs of the appeal chamber judgment. That is the disposition. Mr. Naletilić and Mr. Martinović, will you please stand? This is the disposition. For the foregoing reasons, the appeal chamber, pursuant to Article 25 of the statute and Rules 117 and 118, noting the respective written submissions of the parties and the arguments they presented at the hearings of 17 and 18 October 2005, sitting in open session. With respect to the prosecution's grounds of appeal, notes that the prosecution's second ground of appeal has been withdrawn. Allows Judge Guiney and Judge Schomburg dissenting the prosecution's fourth ground of appeal. Affirms Naletilić's conviction for torture as a crime against humanity under count 9 of the indictment, and holds that the conduct underlying this conviction encompasses, inter alia, the mistreatment of witnesses F, F, and Z. Dismisses, Judge Schomburg dissenting in part, the prosecution's remaining grounds of appeal. With respect to Naletilic's ground of appeal, allows in part Naletilic's first and third ground of appeal insofar as they relate to Naletilic's superior responsibility for the beatings administered by Miro Marjanović to prisoners at the Heliodrome. Allows, in part, Naletilic's 21st grounds of appeal insofar as it relates to Naletilic's superior responsibility for the mistreatment of prisoners in Ljubuški prison. Sets aside his conviction for willfully causing great suffering or serious injury to body or health as a grave breach of the Geneva Conventions of 1949 under count 12 of the indictment, insofar as the conduct underlying this conviction encompasses the beating of prisoners at the Heliodrome administered by Miro Marjanović. Sets aside his convictions for persecutions on political, racial, and religious grounds as crimes against humanity under count 1 of the indictment, and for willfully causing great suffering or serious injury to body or health as a grave breach of the Geneva Conventions of 1949 under count 12 on the indictment, insofar as the conduct underlying these convictions encompasses the incidents of mistreatment of prisoners in Ljubuški prison. Dismisses Naletilic's remaining grounds of appeal against conviction and sentence in all other respects, and affirms Naletilic's sentence of 20 years imprisonment subject to credit being given under Rule 101C for the period already spent in detention. With respect to Martinovic's ground of appeal, allows in part Martinovic's second ground of appeal insofar as it relates to the defects in the indictment regarding the pleading of turning a private property into the headquarters of the Vinko Šrobo ITG, the incident of beating in July or August 93 involving several prisoners, and the incident of beating involving a prisoner called Tsotsa, and sets aside his conviction for unlawful labor as a violation of the laws or customs of war under count 5 of the indictment, insofar as the conduct underlying this conviction encompasses the incident of turning a private property into the headquarters of the Vinko Šrobo ATG, and his conviction for willfully causing great suffering or serious injury to body or health as a grave breach of the Geneva Conventions of 1949 under count 12, insofar as the conduct underlying this conviction encompasses the incidents of beating of detainees in July or August 93 and of a detainee called Tsotsa. Dismisses Martinovic's remaining grounds of appeal against convictions and sentence in all other respects, and affirms Martinovic's sentence of 18 years imprisonment subject to credit being given under Rule 101C for the period already spent in detention. And finally, rules that this judgment shall be enforced immediately pursuant to Rule 118 of the rules, and orders in accordance with Rule 103C and Rule 107 that Naletilić and Martinović are to remain in the custody of the International Tribunal pending the finalization of arrangements for their transfer to the state where their sentence will be served. Mr. Naletilić and Mr. Martinović, you may be seated. I now request the registrar to please deliver copies of the judgment to the parties in this case. Please, Madam Registrar. Thank you, Madam Registrar. This hearing of the Appeal Chamber of the International Criminal Tribunal for the former Yugoslavia stands adjourned.
All rise for your vote of aye.
Yeah.